41 inch. That is only for calculation mistakes. I have information mistake. Yes, miss.
Who has done calculations?
Just the tribunal has overlooked. I'm informed Ashutosh Anand.
Call him.
Let's.
Call him later. Serial number 41. Yes.
I'll just call him.
There are two cases on 12 and 13. 12 have been filed by me and 13 cross objection filed by the claimants. Claimant's lawyer is Mr. Tapeshwar Nath Mishra. Due to some medical reasons, he has gone to
Pray for adjournment. Let the case be called out. आपको तो medical problem नहीं है?
हमको नहीं हम
हाँ तो बस रुकिए थोड़ी देर.
उन्हीं का रिक्वेस्ट आया था इसलिए
कोई बात नहीं.
हम तो है ही.
पर mention मत करिए.
From supplementary list for final resolution item 1 MA 195 of 2020.
Yesterday you had given that judgment, right?
Yes, ma'am. I have verified judgments by yours. There is no direct judgment, but several judgments are there, where without my lords expressing any opinion, merely because the learned tribunal has granted future prospect, the Honorable High Court has refused to interfere in some cases.
In our court also?
No, not in our court. I think Bombay High Court as well as in some courts.
Judgment कहाँ चला गया जो कल
ये यहाँ पर है.
ये एक सेकंड.
दूसरा my lords, जो जजमेंट हमारे 163 में नहीं देना है, वो जजमेंट ऑनरेबल तेलंगाना हाई कोर्ट का, सिक्किम हाई कोर्ट का और बॉम्बे हाई कोर्ट औरंगाबाद बेंच का वेरी टाइम प्रॉपर्ली डिस्कस कि क्यों नहीं देना है. आई ब्रॉट दो जजमेंट्स.
ये आप कौन सा हाई कोर्ट का प्रेजेंट किए थे कल?
I have placed of Bombay.
तो ये बॉम्बे हाई कोर्ट का ही कॉन्ट्रडिक्ट बता रहे हैं.
वही हम बता रहे हैं कि देयर इज नथिंग मेंशन्ड इन दिस हियर मैटर.
नहीं सुप्रीम कोर्ट का जजमेंट है आपको दिखा.
सुप्रीम कोर्ट का
I have
जजमेंट है
also
my
brought
lords
few judgments. One of Supreme Court Honorable Apex Court only on the point that it has to be given.
हाँ शो मी.
Yes.
बात खत्म हो जाएगा ना. फिर हाई कोर्ट में कहाँ घूम रहे हैं हम लोग?
Yes.
अब जजमेंट दिखाइए.
And relying on that judgment, I have brought 3-4 more judgments that it has to be given.
और अदर साइड को भी दीजिए.
Other side.
This judgment you are relying upon?
This R.K. Malik.
Okay. Paragraph number?
Before going to that judgment, I will show the recent judgment.
First show me, this is the parent judgment.
Yes, in this, this has been discussed while relying on it. There are two paragraphs. Para 3 may kindly be seen, which shows that this application is under 163A. It is alleged that the driver was driving the bus in rash and negligent manner and the very first speed. Further is that the bus driver lost control and the bus, after breaking railing the bridge on the left side, the same fell into river Yamuna. The applicants filed claim petition individually on account of fault liability and sought for payment of compensation under section 163A. That is it.
Then which paragraph?
Now, simply kindly come to para 36. Para 36, page 41. 42. Yes, page 41. In Lata Wadhwa and MS Gherewal, the Supreme Court recognized such future prospects as the basis and factor to be considered. Therefore, denying compensation over future prospects seems to be unjustified. Keeping in this background the facts and circumstances of the case in the following decision of Lata Wadhwa, we deem it fit appropriate to grant compensation of rupees 75,000. And this is a judgment of 2009. At that time, future prospects was not standardized. 75,000, which is roughly half the amount given on account of pecuniary damages as compensation for the future prospects of the children to be paid to each claimant within 1 month of the date of decision. We would like to clarify this amount of 75,000 is over and above what has been awarded. Now, considering this 40% and considering the judgment of Delhi Pranay Sethi of the Honorable Apex Court.
Just a moment. This judgment is not yet over. Para 26.
26. While quantifying and arriving at the figure of loss of expectation of life, the court has to keep in mind that this figure is not to be calculated for prospective loss of further pecuniary benefit that have been awarded
Prospective loss or further pecuniary benefit. आगे बताइए.
or further pecuniary benefit that have been awarded under another head, i.e. pecuniary loss. The compensation payable under this head is for loss of life and not loss of future pecuniary prospects. Under this head, compensation is paid for termination of life, which results in constant pain and suffering. The pain and suffering does not depend upon the financial position of the victim or the claimant, but rather on the capacity and the ability of the deceased to provide happiness to the claimant. This compensation is paid for prospective happiness, which the claimant victim would have enjoyed had the child not died at a tender age. Finding is that the future prospects has to be given, and relying on that, this particular judgment itself, I have given 3 more judgments. One is of Delhi High Court also.
This Lata Vadva and MS Girewal is on 163.
Yes, 163. They have relied on that. This judgment is on 163, and relying on Lata Vadva, they have said that 75,000 is to be granted. The reason for 75,000 today has to be 40%, because that time Pranay Sethi did not, no judgment was there to standardize the future prospects. Now it has been standardized, that there is no dispute about that, whether what percentage of future prospect is to be given. That is settled. At the relevant time, it was not as standardized, that is why 75,000 was given. The law that whether it has to be given or not is clarified on this. And based on this, I am relying upon 3 judgments, recent judgments. One is of 22, one is of, first I will, let's say, we kindly see one of Guwahati High Court.
Just a moment. Future prospects is given for children or for whom?
Future prospects, this case talks about future prospects under 163A in my submission.
Future prospects of the deceased.
Deceased. 163A.
This is a judgment on future prospects of children.
Right.
There is a difference between them.
But provision of law under which it has been filed is to be referred to. And for that purpose, I have brought
Future prospects of children and future prospects of the victim are 2 different things altogether. Isn't it one and the same thing? How do you say that both
under
are
the
one?
provision, which provision it has been filed, it is the question of law in this case, which I would also clarify from the judgment I am relying upon in another case, is that whether under 163A, future prospects can be given or not. That is the question.
That's right.
Whether-
Whether it has to be guided strictly by the schedule,
Yes, it has to be guided strictly by the schedule.
or additionally future prospects of the deceased is to be taken into consideration.
In view of Pranay Sethi. That is
No,
my-
I think I have read a judgment for 20.
एक मेरे अगेंस्ट जजमेंट भी है जो बात करता है इसी पॉइंट पर कि क्यों नहीं मिलना चाहिए, दिल्ली हाई कोर्ट का ये मैम, एंड दैट सेज, एंड दैट जजमेंट इज ऑफ द ईयर 2016. आई जस्ट रीड वन पैराग्राफ ऑफ दैट जजमेंट, पैरा 5. This I perhaps have not given a copy of this. This judgment, this is against me. It will clarify the question that what is the point why under 163A it cannot be given. The present judgment I am given.
Just a moment. Please open.
That is against me.
Future prospects of a child is very much different from the future prospect of.
Now to answer that, the judgment I just gave of Delhi High Court, that is 2016 SCC Online, Delhi 3058. that is against me. I will clarify why under 163 it was not given earlier, before Pranay Sethi. I am again going to Pranay Sethi.
Delhi High Court.
Delhi High Court, 2016 SCC online, DEL 3058. Very small judgment, 2 pages, but para 5. This judgment is against me, but this judgment is of 2016. Para 5 I read.
Yes, read it please.
Against the above backdrop, by judgment dated such and such, passed in MSc number such and such, this court has found it proper to follow view taken earlier in learned single judge in MSc number such and such, decided on 12/1/15. Presently, taking the decision in Resma Kumari as the binding precedent, till such time the law on the subject of future prospects for those who are self-employed or engaged in gainful employment at fixed salary is clarified by a larger bench of the Supreme Court. So this is the main thing, that earlier why it was not being given, because there was no notion that a person who is self-employed or a person who is on a fixed salary can be given future prospects or not. So after coming into force of Pranay Sethi and all the other judgments, the recent judgments of different high courts I am relying upon, talks about Pranay Sethi itself. And Pranay Sethi does not distinguish between 163A and 166.
Pranay Sethi deals with 163A.
Yes, it has dealt with 163A. It talks about that multiplier, what multiplier is to be applied, what would be the relevant age which is to be taken.
That's right.
So
those
these
are,
things
those
are
are
the-
the factors.
And at the
Those
end,
are the factors at par for both the sections.
everything.
Right. But
While dealing with future prospects, at paragraph number 57,
when we
perhaps,
talk about future prospects, there are two aspects of the matter. One is the future prospect of the deceased. Suppose he is a very good student, or maybe that he is very well employed. Then some kind of future prospects you can think of.
Right.
Right? This is one nature of future prospects. The other nature of future prospects is he has small kids, or maybe they are deprived of certain benefits because of his death.
no, that will not come into picture in future prospects.
Oh.
Future
Only with regard to the deceased.
only with regard to the deceased. For future prospects, only the deceased consideration is there, not the dependents.
Okay.
So deceased, earlier only people who were employed were giving on a permanent job were giving future prospects because there was chance of increment and promotion and
That's it.
other benefits.
That's
Now after coming into force of this judgment which I relied on Delhi High Court, this talks about that only. This also clarified me that what is the reason that earlier it was not being given. While Pranay Sethi dealt that even person who are self-employed or on a fixed salary, mason, rickshaw puller or anyone shall be given future prospects as per the heads described under Pranay Sethi.
That's right. They are entitled to future prospect.
Right.
There is no doubt on that. But the point is that when the proceeding is under section 163A, whether they will be entitled for future
So-
prospect, irrespective of the fact whether they are self-employed
Yes.
or they are government employees. Therefore, under section 163A, whether they will be entitled for
So
future
relying on this judgment, R.K. Malik, I will rely upon 3 judgments which I have given below. Those are very small judgments. I'll give the categorical paragraphs. One is of Delhi High Court 2017. That is 2017 SCC online DEL 11706. This para 3.
Yes.
Para 3, the insurer will be insurer by appeal at hand question the said calculation contesting the tribunal fell into error by adding the element of future prospects of increase which was uncalled for. A case under 163 of the Motor Vehicle Act, it is submitted that the tribunal has failed. And para 5 now, the claimants had not been able to prove a regular income of the deceased, and therefore the tribunal was constrained to go by the minimum wages of 2,579, and therefore the tribunal was 79 per month. The decision in Pranay Sethi makes no distinction between a claim under 166 or under section 163 of the Motor Vehicle Act for assessing the income. Since the element of future prospects for increase would deserve to be added to the extent of 40% in view of the ruling in Pranay Sethi, the suitable corrections also need to be made on the issue of multiplier. So other things are relevant to this case. This is the finding. Based on this, future prospects was given 40% in this case. In para 5 only it has been given.
Where is the judgment of Pranay Shetty?
Pranay Shetty, it is reported in 2017, volume 16, SEC, page 680.
Manali? तो बोले थे ना सुबह Pranay Shetty बनाना. Pranay Shetty भी चाहिए, Sadla Verma भी चाहिए. And this has been followed in subsequent judgment also?
Yes.
Which one?
Now, this Guwahati High Court judgment decided on 17/11/2017. First, I will rely on para 9. Para 9, page 3 of the judgment. I have heard the learned counsel for the parties. In the case of R.K. Malik, Kiran Pal, reported in 2009, the apex court has held that in para 32 of the denying compensation towards future prospects seems to be unjustified. Accordingly, the apex court has awarded compensation for future prospects on a claim made under section 163 of the Motor Vehicle Act 1988. And para 17 is the finding. 17. Yes, 17. Mary, para 17. The case of Deepal Yusasam Supra Uthamma and in the National Insurance Company versus Pranay Shetty, SLP number 67, the apex court has held that the principle relating to determining the liability of quantum of compensation were different of claim made under 163A and claim made under 166. There is no specific observation in the above cases that compensation cannot be given with regard to conventional head in respect of claim made under 163A. The apex court basically held that claimant cannot pursue his remedies simultaneously under 163A and 166 of the MV Act. And the next judgment is of 2022, 28 to 2022 of Guwahati High Court itself. In this para number 8, 12 and 19. This has relied on this Guwahati High Court judgment, the earlier, as well as R.K. Malik and Pranay Shetty. Para 8 would clarify that this is also under 163A. From the middle, para 8, if I may read, that the learned tribunal has added amount under the conventional head which are not reflected in second schedule of the MV Act, while the claimant had made a claim under section 163 of the Act. In support of his submission, the learned counsel for appellant has relied on the judgment in Sitaram Motilal Kale versus such and such AIR 1960. Pushpa Bai, Purushottam, Udesi and others versus Mrs. Ranjit, representative manager. Now, question of law has been framed in this case at para 12. Para 12, point number 3. Whether the conventional head, which are not reflected in the second schedule of MV Act 1988, can be awarded to the claimant who has made a claim under section 163A of the Act. And to this, the Honorable Court has answered in para 19, relying on the judgment of R.K. Malik as well as the previous judgment of Guwahati High Court, which I relied on.
Where is the issue framed?
Issue at page para 12, point number 3.
And decided in?
And decided in point number 19, because in this other
Point
issue,
number?
19. With regards to the issue that when an application is filed under 163A of the Act, whether the learned tribunal can pass an award under conventional head, which are not in the second schedule of the MV Act, this court in MAC Act number 17 of 17 dated 17/11/17 has dealt with the matter wherein relying upon the case of R.K. Malik and another reported in such and such, where apex court has held that denying compensation towards future prospects would seem unjustified, and accordingly apex court has awarded compensation for future prospects on a claim made under 163 of the MVR, and also held that there is no infirmity in High Court in granting 75,000 for non-pecuniary damages. This court had allowed an award under conventional head, which was not in the second schedule of the MVR. Thus, I will not find necessary to discuss the matter any further, since the issue is covered therein. These are the judgments I have.
So this is one Arunachal Pradesh, one is Guwahati. Basically, they are following this R.K. Malik judgment.
Yeah, two judgments are simultaneous, and R.K. Malik and Pranay Shetty main basis is prenacity. 40% I am claiming. So the basis is prenacity. Otherwise, there was no standardization. Prenacity does not distinguishes between 163A and 166. That is my submission. So far as future prospects is concerned.
So Delhi High Court has given future prospects with.
Yes,
with
Delhi High
reference
Court has
to,
given,
Uh,
and earlier it has not given.
Bombay High Court has also given.
That also I have given a lot, and two other judgments. One which was dissenting against me, that is of the year 2016, before coming into force of prenacity. That is against me, which says that since there was no standard calculation for self-employment,
That's right.
that is my. That's all.
Just- In Pranesh Shetty, how is the future prospect calculated?
Yes, para 57 that is. I have.
Pranesh Shetty. So you want to say that under the standardized formula, under the schedule, whatever is there that has to be paid over and above, some amount on account of future prospects has to be
Yes.
paid
And
because that is not relatable to earning of a person.
Right, and conventional advice. In this judgment also, judgment which is before your lordship in appeal, conventional has been paid to a tune of 70,000 rupees in view of Pranay Sethi. Second schedule provides for only 9,500 rupees. What prevented the company to challenge that?
So under the conventional head, 70,000 has been paid.
Yes, under loss of consortium 40,000, loss of estate 15,000, and funeral expenses 15,000.
And what about future prospects?
Nothing
It is silent.
Nothing has been discussed only.
It is silent.
Yes.
So you want to say that over and above whatever is payable, under 3 heads payment has been made, but 1 head has been ignored completely.
Yes. That is my solution.
Yes, what do you have to say?
The judgment upon which I am relying on,
Like,
sir,
Pranay Shetty wala-
it was
Pranay Shetty has been considered in this?
yes.
This is Gangtok.
First judgment in Gangtok, the matter was referred to division bench because there are conflicting decisions between the two single judges. Therefore, the matter was sent to the division bench, and from para 7 onwards, my lords, you kindly see I'll place that matter. It discusses the entire history of 163A, my lords, and also discusses the judgment relied upon by my friend Lata Vadhava and all that.
Lata Vadhva and this Malik.
Yes, it is there, my lords. Lata Vadhava was Malik was on the basis of Lata Vadhava. Para 7 onwards, I am placing my lords. Para 7, my lord has got that.
Yes, I got.
It is no longer res integra that compensation to be granted under Section 166 and Section 163A of the MV Act differ from each other, and the remedies under Section 163A and 166 are distinct based on different legal regimes. Section 163A deals with payment of compensation on a structured formula basis on the principle of strict liability, where the claimant is not required to plead or establish that death or permanent disablement in respect of which the claim was made was due to any wrongful act or neglect or default of the owner of the vehicle or vehicles concerned or of any other person. While on this point, it would be worthwhile to refer to the background of the insertion of Section 163A into the Act. In the 85th report on claims for compensation under Chapter 8 of the Motor Vehicle Act 1939 of the Law Commission of India, May 1918, Chapter 3, liability without fault, 2 new measures were proposed. Introduction of Section 92A in the Motor Vehicles Act 1939, by which doctrine of no fault liability was to be introduced, and imposition of strict liability on death or bodily injury caused by an accident as specified in Section 110(1) of the same Act. Section 92A and 92B, whereby no fault liability was inserted in the MV Act of 1982 with provision of Rs 15,000 in case of death and sum of Rs 75,000 in respect of permanent disablement. Section 92A to Section 92E of the 1939 Act were replaced by Section 140 to Section 144 of the MV Act of 1988. The amount of compensation in case of death was raised to Rs 50,000 and for permanent disablement to Rs 25,000. A review committee was constituted by the Government of India in 1990, and in view of the recommendations of the review committee and the Transport Development Council, the Act was amended in 1994, whereby Section 163A came to be inserted for payment of compensation on no fault basis or strict liability on a structured formula. At this juncture, it is clarified that there is no necessity for this court to enter into a prolix discussion on Section 166 and Section 140 of the MV Act or its insertion by way of amendment and its consequent implications. We will confine ourselves to the provisions of Section 163A of the MV Act and reference made to this court. The origin of the theory of strict liability, as inserted in Section 163A of the MV Act for hazardous activities, can be traced to the judgment of Blackburn Justice in Raylands versus Fletcher in November 1861. Fletcher brought an action against Raylands and Horrocks.
You can skip that.
My lords.
You
Then
just
my
come
lords,
to the findings.
10. Finding, yes, finding.
Dipali
Dipal,
Soni.
yes, yeah, 11 support, 11. In Dipal agrees by Soni, the question that arose before the Honorable Supreme Court on appeal was whether a proceeding under Section 163 of the MV Act is a final proceeding and claimant to be granted compensation thereunder is debarred from making a claim under Section 166 of the Act as well. The Supreme Court inter alia held that provisions of Section 163A of the MV Act was inserted by way of social security scheme and is a code by itself. It was elucidated therein that it appears from the objects and regions of the Motor Vehicles Amendment Act 1994 that after enactment of the 1988 Act, several representations and suggestions were made by the state governments, transport operators, and members of the public in relation to certain provisions thereof. Taking note of the observations made by the various courts and difficulties experienced in implementing the various provisions of the Motor Vehicles Act, the Government of India appointed a review committee. Review committee in its report made the following recommendations inter alia: that 88 Act provides for enhanced compensation for hit and run cases as well as for no fault liability cases. It also provides for payment of compensation on proof of fault basis to the extent of actual liability incurred, which ultimately means an unlimited liability in accident cases. Their proposals had been made from time to time that the finalization of compensation claims would be greatly facilitated to the advantage of the claimant and vehicle owner as well as insurance company if a system of structured compensation can be introduced. Under such a system of structured compensation that is payable for different classes of cases depending upon the age of the deceased, monthly income at the time of death, earning potential in case of minor, loss of income on account of loss of limb, etc., can be notified. The affected party can then have the option of either accepting the lump sum compensation as notified in that scheme of structured compensation or of pursuing his claim through normal channels. That the recommendations of the review committee and the presentations from the public were placed before the Transport Development Council for seeking their views pursuant whereto several sections were amended. Section 163A was inserted in the Act to provide for payment of compensation in motor accident cases in accordance with second schedule, providing for structured formula which may be amended by the central government from time to time. That Section 140 of the Act dealt with entry compensation, but by inserting Section 163A, Parliament intended to provide for making of an award consisting of a predetermined sum without insisting on a long-drawn trial or without proof of negligence in calling the execution. The amendment was thus a deviation from the common law liability under the law of torts and was also in derogation of the provisions of the Fatal Accident Act. That the Act in no uncertain terms suggested that a new device was sought to be evolved so as to grant a quick and efficacious relief to the victims falling within the specified category. The heirs of the deceased or any victim in terms of the said provisions were assured of a speedy and effective remedy which was not available to the claimants under Section 166 of the Act. That Section 163A was thus enacted for grant of immediate relief to a section of the people whose annual income is not more than ₹40,000. Having regard to the fact that in terms of Section 163 of the Act, read with second schedule appended thereto, compensation is to be paid on a structured formula, not only having regard to age of the victim, but his income, but also other factors relevant therefore. An award made thereunder, therefore, would mean full and final settlement of the claim as shall appear from the different columns contained in the second schedule appended to the Act. The same is not interim in nature. The note appended to column 1, which deals with fatal accidents, makes the position furthermore clear, stating that from the total amount of compensation, 1/3 thereof is to be reduced in consideration of expenses which the victim would have incurred towards maintaining himself had he been alive. This, together with other heads of compensation as contained in column 2 to 6, leaves no manner of doubt that Parliament intended to lay a comprehensive scheme for the purpose of grant of adequate compensation to a section of victims who will require the amount of compensation without fighting any protracted litigation for providing that the accident occurred owing to negligence on part of driver of the motor vehicle or any other fault arising out of use of a motor vehicle. The judgment went on to explain that under Section 163A of the compensation is required to be determined on the basis of a structured formula where in terms of Section 140 only a fixed amount is to be given. That the scheme initiated under Section 163A left no doubt that by reason thereof the rights and obligations of the parties were to be determined finally. The amount of compensation payable under the aforementioned provisions was not to be altered or varied in any other proceedings, neither did it contain any provision providing for set-off against a higher compensation unlike Section 140. In terms of the said provision, a distinct and specified class of citizens, namely persons whose income per annum is 40,000 only or less, is covered thereunder, whereas Section 140 and 160 cater to all sections of society. It was opined that the remedy for payment of compensation, both under Section 163A and 160 being final and independent of each other as statutorily provided, a claimant cannot pursue the remedy thereunder simultaneously. One thus must elect to go either for proceeding under Section 163A or under Section 160 of the Act, but not under both. 12. Para 12 minors. Later in the time in 2009, Guru Mallamma, a two-judge bench, opined that Section 163A was inserted by Act 54/94 as a special measure to ameliorate the difficulties of the family members of a deceased who died in the use of a motor vehicle It contains a non-obstant clause. It makes the owner of the motor vehicle or the authorized insurer liable to pay in case of death the amount of compensation as indicated in second schedule to his legal heirs. The second schedule provides for amount of compensation for third-party fatal accident injury cases claims. It provides for age of the victim and also provides for multiplier for arriving at the amount of compensation which became payable to the heirs and legal representatives of the deceased, depending upon his annual income. The second schedule furthermore provides that in a case of fatal accident, the amount of claim shall be reduced by 1/3 in consideration of the expenses which the victim would have incurred upon himself had he been alive. It provides for the amount of minimum compensation of ₹50,000. It furthermore provides for payment of general damages as specified in Note 3 thereof. The tribunal in a proceeding under Section 163A of the Act is required to determine the amount of compensation as specified in Section 6. It is not required to apply the multiplier except in a case of injury and disability. In Putamma, a two-judge bench, while dealing with a claim petition under Section 166 of the India Act in appeal, observed that second schedule was redundant, irrational, unworkable, and suggested that central government amend the second schedule. In Reshma Kumari, Supreme Court again reiterated what had been held in the Bal against by Sony and observed that the 1988 Act gives a choice to the claimant to seek compensation on structured formula basis as provided in Section 163A or make an application for compensation arising out of an accident of the nature specified in subsection 1 of Section 165 under Section 166. By incorporating Section 163A in the 1988 Act, Parliament had provided the remedy for payment of compensation notwithstanding anything contained in the 88 Act or in any other law for the time being force or instrument having the force of law, that the owner of a motor vehicle or authorized insurer shall be liable to pay compensation on the structured formula basis as indicated in the second schedule in the case of death or permanent disablement due to accident arising out of use of motor vehicle. The peculiar feature of Section 163A is that for a claim made thereunder, the claimants are not required to plead or establish that death or permanent disablement in respect of which the claim has been made was due to any wrongful act or neglect or default of owner or owners of the vehicle concerned. The scheme of Section 163A is departure from general principle of law taught that the liability of the owner of the vehicle to compensate the victim or his heirs in a motor accident arises only on the proof of negligence on the part of the driver. Section 163A has done away with the requirement of proof of negligence on part of the driver of the vehicle where the victim of an accident or his dependents elect to apply for compensation under Section 163A. When an application for compensation is made under Section 163A of the compensation is paid as indicated in Section Schedule, the table in Section Schedule has been found by this court to be defective, in which we shall refer to a little later stage. And now, my lords, para 15 is the finding of the court. Honorable Court. These observations unequivocally clarify that compensation under Section 163A is based on strict liability. In other words, the requirement of proof of negligence on part of driver is done away with under Section 163A. So far as reliance on punacity by Land Council for Respondent 1 to 5 is concerned, we are in agreement with the Land Council appearing on behalf of the Bar Association of Sikkim, and reliance by Land Council for the Respondent 1 to 5 on the ratio is a misconception of the law. The ratio observes inter alia that the determination of income while computing compensation has to include future prospects, so that the method will come within the ambit and sweep of just compensation as postulated under Section 168 of the NB Act. It needs no reiteration that the Supreme Court has clearly spelled out as evident from the decision cited Sudha that compensation to be computed under Section 163 of the Act is on a structured formula as is based on no fault liability. Once a person invokes the provisions of Section 163A, the question of inclusion of pecuniary compensation for non-tangibles and future prospects does not arise. The ratio in R.K. Malik, which adverse to the
163A, while calculating, I've seen this, I've read it. While calculating compensation under Section 163A, the income is made the basis.
yes,
Income is made the basis. So, future, I have read one judgment yesterday which says that the future prospect, because that particular person was to be promoted immediately.
yes, yes, sir.
कौन सा वाला judgment?
That lie है, दो नौ का judgment lie है. I'm placing that.
कहाँ है वो judgment?
यहाँ है, मेरे पास है.
वही हम खोज रहे हैं, कल से हम उसी को खोजे हैं।
नहीं वो है.
वो है, उसमें लिखा हुआ है कि फ्यूचर प्रॉस्पेक्ट बस उतना ही हद तक टेकअप होगा, उसके बियॉन्ड 163A में नहीं होगा।
नहीं होगा, वो हम लाए हैं. पैरा 13.
और हम खोज रहे हैं ये 2009 का भी ये दिया, इसीलिए बार बार इसी को पढ़ रहे हैं कि पढ़े थे कल, आज नहीं दिख रहा हमको।
हम असल में उसको इसलिए प्लेस है औरंगाबाद वाला जजमेंट है पहले और दैट है डिस्कस प्रणय सेठी एंड सरला वर्मा एंड सेड दैट इज ओनली विद रिस्पेक्ट टू 160 इसीलिए हम इसको लास्ट में देने वाले थे पैरा 13 में है
हाँ पैरा 13 हम देखे हैं उसको हमको याद आ रहा है कल हम
well that is the observation of honorable supreme court Mr Nanda
उनको दीजिए
पैरा 13
बढ़िया
Mr. Nanda may be correct to some extent that for the purpose of computation of total amount of compensation under section 163A of the Motor Vehicle Act, the future prospect may not be of much relevance. But in a case where a claim petition has been filed in terms of section 166 of the Act, the same would, in our opinion, be a relevant factor. It was a case under section 166. At that time, my lords, the future prospect law was not crystallized. Therefore, the Honorable Supreme Court said that since the deceased was to get my lord's promotion immediately in the near future, therefore that
should be added in his income.
Yes,
And then the entire
Yes.
compensation was to be calculated.
yes, and therefore it has been observed that since it is a case under section 166, and it is also mentioned that may not be much relevance in the under section 160A. That was a case
And
under
it is by the same bench also.
yes,
ये वाला जो जजमेंट आप दिए हैं और ये जो सेम बेंच का जजमेंट है और एकदम प्रॉक्सिमिटी में है दिस इज May 6, 2009 दिस इज May 15, 2009 है ना
औरंगाबाद वाला
और
judgment-
यू सी सो फार एज चिल्ड्रन आर कंसर्न उनका कोई फ्यूचर प्रोस्पेक्ट्स बोल के तो कोई बोल नहीं सकते हैं क्योंकि उनका कोई इनकम नहीं होता है दिस इज हाउ दे हैव डिस्टिंग्विश्ड द जजमेंट ऑफ दिस पर्टिकुलर आर.के. मलिक by saying that since it was a case of compensation for deceased children, therefore there is no question of any kind of उन लोगों का एक future prospect करके उनके ऊपर that was the basis for quantifying the compensation.
But there is no finding in this that it cannot be granted in this judgment. So far as I can read, just my senior has given me. I could not find any finding that
Para
it cannot
13,
be. Para 13. Yes.
And Mr. Nanda may be correct to some extent. No
Extent.
finding, but that is an
May
observation.
be correct, but at the same time, Pranay Sethi when came into
औरंगाबाद
existence,
वाला
and
जजमेंट
why?
है औरंगाबाद वाला जजमेंट है उसको भी एक बार देख लिया जाएगा पैरा 11 onwards it and प्रणय सेठी एंड सरला वर्मा हैव बीन डिस्कस्ड
ये वाला जो आप
ये फर्स्ट अपील का ये कोर्ट से ही निकाला हुआ इन द हाई कोर्ट ऑफ जुडिकेचर एट बॉम्बे बेंच एट औरंगाबाद ये कोर्ट के वेबसाइट से निकाला है
अच्छा
पैरा 10 से 14 खाली एक बार देख लीजिए पैरा 10 खाली इसीलिए है कि उसमें दिस इशू हैज बीन मेंशन्ड एंड देन डिस्कस्ड 11 onwards पेज नंबर 5 है I'm
the
placing
most
that.
important point.
Yes, the most important point which first arises for my consideration is whether in petitions filed under section 163A of the MV Act, the ratio or law laid down by the apex court in Srimati Sarla Verma and others versus Delhi Transport Corporation and National Insurance Company versus Pranay Sethi or Reshma Kumari versus Madan Mohan is applicable. Now it has been discussed. Therefore, I have carefully gone through these three cases and I am fully satisfied that in those matters, the apex court was considering applicability of proper multiplier, proper deductions, compensation for loss of future prospects and proper compensation under conventional acts only in petitions filed under section 166 of the MV Act. In para 18 of the judgment in the case of Srimati Sarla Verma, the apex court observed that the principle relating to determination of liability and quantum of compensation are different for claims made under section 163A of the MV Act and claims under section 166 of the MV Act. In para number 20 of the judgment, the apex court observed that we are concerned with cases falling under section 166 of the MV Act and not under C of the MV Act. Even in Reshma Kumari, in paragraph number 10 and 11 of the judgment, the apex court observed that in 1988 Act gives choice to the claimants to seek compensation on a structured formula basis as provided in section 163 of the MV Act or make an application for compensation arising out of an accident of the nature specified in subsection 1 of section 165 under subsection 166 of the Act. The claimants have to elect one of the two remedies provided in the Section 163A and Section 166 of the MBA Act. The remedy provided in Section 163A is not a remedy in addition to the remedy provided in Section 166, but it provides for alternative course to Section 166 of the MBA Act. Under Section 163 of the MBA Act, claimants are not required to plead or establish that death or permanent disablement in respect of which the claim has been made was due to any wrongful act or neglect or default of owner or owners of the vehicle concerned.
That's right. Para number 12 crystallizes that those
Sure.
matters were under section 166 of MD
Yes.
Act only. Even in national insurance,
Yes.
it was
Even in
166.
national insurance, para 13, my lord, even in national insurance was a penalty, larger bench considered the applicability of proper multiplier, compulsory deduction for personal expenses, additional compensation for loss of future prospects, and proper compensation and conventional that is loss of consortium, loss of state influence concern only in claim petitions filed under section 166. The law laid down by the apex committee never referred cases were not applicable in the claim petition filed under section 163A of the MBA. So, my lords, the observation that 160, this has come, my lord, because there was some feeling.
Under schedule,
Yes.
under second schedule, para 17 देखिए.
Yes.
para 17.
Right.
फ्यूनरल दिया हुआ है, लॉस ऑफ
दिया
कंसोर्शियम
हुआ है।
दिया हुआ है, लॉस ऑफ एस्टेट शेड्यूल 2 में ही है.
है.
It's a part of schedule
Yes,
2.
ma'am.
That is why they have the
Given.
learned court has given.
Yes.
But
you-
that schedule gives only 9,500.
Yes. So
So this, but the court below, in my case also has followed Pranay Sethi, and I am
no, Pranay
to
Shetty.
reply
You see, just
once
a
my
moment.
senior finishes
Just a
argument.
moment,
I'll
just a
reply.
moment. You will respond. That is okay. What I want to say is, and so far as funeral expenses is concerned, be it under 163 capital A or 166, there is no difference between the two, isn't it? This funeral expenses which has been enhanced by way of Pranay Shetty could be to some extent applicable in Schedule 2 also, because funeral expenses will not vary.
No, because earlier, before coming into force of Pranay Sethi, funeral expenses under 166A was being given 50,000. Under love and affection was another head. Under conventional head, 1 lakh to each of the dependent was being given. So Pranay Sethi standardized this. It said that, and I'll come to Pranay Sethi now to reply to all the contentions. It will clarify the doubts. You know, we kindly refer to
So
para
let
3 of
us,
the Pranay Sethi.
it was both 163A एक बार जरा देखो.
In totality, just one submission is there.
163A में subheads क्या है?
Subheads are there to the extent of 9,500 total. This book.
Schedule is there, what second schedule. In my GPT at page 187 after the act. He is saying that since it has been given as per Pranay Sethi, we should have challenged that. He is saying this. And if you have not challenged, then you have no right to.
नहीं ये नहीं submission.
Second schedule.
Second schedule is table, my lords, and on the
Yes.
next page,
Just a moment. Let us see.
it says, my lords, what will be the age and what will be the multiplier.
What is this rupees 3,000?
That is the income they are saying, my lords, 3,000 annual income.
Okay.
If it is a case of 3,000, then what will be then 40,000 is the last.
Okay.
Next page, my lords, will see the non-conventional heads.
Yes.
Amount of compensation shall not be less than 50,000 and general damages. The following general damages shall be payable in addition to compensation outlined above. Funeral expenses 2,000, loss of consortium 5,000, loss of estate 2,500. And medical expenses, actual expenses incurred before death supported by bills but not exceeding 15,000. This is the case in case of death.
Loss of income.
Yes. So since this schedule was
Notional income for compensation for those who had no income prior to accident. Non-earning member and spouse.
Yes.
There is one judgment we were reading just now, which holds that 163A with the schedule is a self-contained code,
Yes.
and it is optional that which one you opt for.
Yes, ma'am. Optional. Only one can be elected. Main issue is that even those persons who are not eligible for getting compensation under section 166. For example, if a driver indulges in some accident takes place.
Suppose a person who is bedridden
Yes.
completely
Mine.
and he dies.
Mine.
Then if a person opts for 163 capital A, he would be entitled to whatever compensation has been fixed over here.
Yes, not like that, ma'am. Supposing a person who is himself negligent and he
Yes.
himself caused the accident,
That's right.
and if he files the case under, if his legal heirs file the case under section 166, they will get nothing because nothing can be paid for all negligence.
That's right. They will go under
163A,
163A.
because he does not have to establish negligence. He will get compensation under section 163A, but he will not get
No,
anything
no.
under section 163A.
Just a moment. A person, he himself is driving the vehicle.
Yes, and
Right?
he himself is negligent.
If he himself is negligent,
Negligent.
and without any further, he dies.
Yes, but he is not the owner, he
There
is
is no
driver.
contributory negligence, nothing.
Yes.
He dies,
Mine.
right?
Mine.
Then he will be covered under the insurance policy.
If he is driver of the owner, if he owner himself no,
If he is the driver of the owner,
then
he will be entitled for compensation under Workmen's Compensation Act.
Employees compensation.
Employees Compensation
as
Act.
also 163A. As also
No.
163A.
How
He can
163?
file, ma'am. Legal heirs can file.
No,
It is-
you
there is
see,
no bar.
no. In case where the driver is there, then basically insurance company is compensating the owner of the vehicle,
Minor.
right? So therefore, in such circumstances, the driver of the vehicle stands in the foot of the owner of the vehicle, and therefore, how will he get compensation?
No,
The
if
driver
he-
would get compensation under section 163A for
Minors,
himself.
I'll withdraw that. I am giving a different example. Supposing minors two vehicles collide.
That is a contributory.
Yes, I
No
withdraw
problem.
that. Yes. Two
Two
vehicles
vehicles collide, there is no
Yes.
problem.
Minor. Then, and if there is negligence of a person.
Irrespective of
Yes.
negligence or no
Minor.
negligence. But if simply suppose somebody goes and falls into a ditch,
Yes, then what if he is driver, then he will get under Workmen's Compensation Act.
Workmen's Compensation.
And if he is owner or his son or his family member, then they will get nothing.
they will get that. That is it.
Yes, ma'am. That is it. Minor is correct.
There is one case here of that nature. आज है वो matter.
हाँ, वो इसमें सदानंद का केस था
आपका
मैडम।
matter है.
उसमें son of driver were driving the motorcycle and dashed with a minor tree.
So let us come to this head. So far as funeral, loss of consortium and loss of state, medical expenses, these are common heads between Schedule 2 and 166.
Yes.
These are common heads.
Right.
The only head which is missing in this Schedule 2 is future prospects.
Yes,
That is not there.
that is.
That is not even statutorily laid down under 166.
Yes, that's not.
That is not laid down, right? So that concept of future prospects having been applied to 166, why should it not be extended by the same yardstick and parameters
Yes.
to Schedule 2? This would be at best his argument,
प्रणय
as I
जी
understand.
में ये चीज आया है, एक बार देख लिया जाए मेरा। बस 2 पैराग्राफ 3 पैराग्राफ है। पैरा 3 जहाँ पर ये रेफरेंस गया है 163A एंड 166 दोनों का, नॉट जस्ट 166।
Para number?
3 starting, para 3 of the judgment. Mary,
Yes.
before we penetrate into the past, it is necessary to note what has been stated in Resma Kumari Rajesh case. Resma Kumari, the 3 judges bench was answering the reference made in Resma Kumari versus Sati. The reference judgment noted divergent of opinion with regard to computation under 163A and 166 of the Motor Vehicle Act and the methodology for computation of future prospects. So this was the reference, and now I will directly come to where the future prospects issue has been dealt with, para 55 and 58, just the 55 and 57, just these two I read. to substantiate my submission that there is no distinction in chronicity with regards to 163A and 166 so far as it relates to future prospects. Para 55. May I read now?
Yes.
Section 166 of 68 of the Act deals with the concept of just compensation, and the same has to be determined on the foundation of fairness, reasonableness, and equitability on acceptable legal standard, because such determination can never be in arithmetical attitude. It can never be perfect. The aim is to achieve an acceptable degree of proximity to arithmetical precision on the basis of materials brought on record in an individual case. The concept of just compensation has to be viewed through the prism of fairness, reasonableness, and non-violation of principle of equitability. In a case of death, the legal heirs of the claimant cannot expend a windfall. Simultaneously, the compensation granted cannot be an apology for compensation. It cannot be pittance, though the discretion vested in the tribunal is quite wide. Yet it is obligatory on part of the tribunal to be guided by the expression that is just compensation. The determination has to be on the foundation of evidence brought on record as regards the age and income of the deceased, and thereafter an apposite multiplier to be applied. The formula relating to multiplier has been clearly stated in Sarla Verma, and it has been approved in Resma Kumari. Now here I would like to stop for a moment. Schedule 2 has been overruled by these two judgments, and Schedule 2 multiplier is not being followed. The rationale in Sarla Verma and Resma Kumari is being followed for multiplication. That is settled.
Irrespective of whatever amount has been mentioned in schedule.
Yes, whatever multiplier is mentioned in schedule.
That is not being.
That is not being followed.
So whatever is being followed is
Sarla Verma and
Reshma
subsequently Resma Kumari, and that same has been reiterated in this pronouncity on the age. Now, the age and income, as stated earlier, have to be established by adducing evidence. The tribunal and the court have to bear in mind that the basic principle lies in pragmatic computation, which is in proximity to reality. It is well accepted norm that money cannot substitute a life lost, but an effort has to be made for grant of just compensation having uniformity of approach. There has to be a balance between the two extremes, that is, a windfall and a pittance, a bonanza and the modicum. In such an adjudication, the duty of the tribunal and the courts is difficult, and hence an endeavor has been made by this court for standardization, which is in ambit includes addition of future prospects on the proven income at present. As far as future prospects are concerned, there has been standardization keeping in view the principle of certainty, stability, and consistency. So again, I would stop here for a moment and read this paragraph again. As far as future prospects are concerned, there has been standardization keeping in view of the principle of certainty, stability, and consistency. So, by this, what the Honorable Apex Court is saying that earlier only the people who are on certain job, who were deemed to be promoted, were being given future prospects, and the same view has been taken by the Delhi High Court in a dissenting view.
Again, para 57.
We approve this principle of standardization so that the specific and certain multiplicand is determined for applying the multiplier on the basis of age. Now, para 57, where future prospects have been discussed. Having bestowed our anxious consideration, we are disposed to think when we accept the principle of standardization, there is really no rationale not to apply the said principle to self-employed or a person who is on a fixed salary, to follow the doctrine of actual income at the time of death, and not to add any amount with regard to future prospects to the income of the for the purpose of determination of multiplicand would be unjust. That determination of income while computing compensation has to include future prospects, so that the method will come within the ambit of suite of just compensation as postulated under section 168 of the Act. In a case of the deceased who has held a permanent job with inbuilt grant of annual increment, there is an acceptable certainty. But to state that the legal representative of the deceased who was on a fixed salary would not.
Para 57 says that to follow the doctrine of actual income at the time of death and not to add any amount with regard to future prospects of the income for the purposes of determination of multiplicand would be unjust. So you want to say that the same principle would apply for the Schedule 2 also.
Here also in my case, income has been assessed as 3,300 rupees. It is not on the basis that he was not earning anything. I claimed that he was earning, court accepted the view and granted me
The present income is this
this
at the time of death.
at the time.
So you want that this income should add
40% future prospects because the deceased was aged about 32 years.
32 years, and that formula has been carved out in the case of Pranay Shetty.
Because it does not distinguishes, that is the only submission in totality between 166 and 163A. It has relied on the principle of just compensation as described under 168 of the MD.
And Schedule 2 is also relatable to income.
Yes, but it has been repealed by way of Sarla Verma, and that is being followed in all cases.
Are you following this Schedule 2 in letter and spirit? And
My lords, now this is.
why, if that is so, there is a fixed amount and multiplier prescribed in Schedule 2, then unless that is amended, you should have no option but to follow that. Are you following?
No, we can appreciate. There are several judgments in which our Supreme Court pointed out that that schedule is not properly, it should be amended. It was
Yes.
never amended by the central government.
But as of now,
Therefore, I am coming to that, my lord.
Yes.
Therefore, the Sarla Verma judgment, my lords, modified that schedule and said that this should be followed. In Sarla Verma judgment, as I read, it was clear that it was only a case under section 166, and it was mentioned that future prospect will be granted.
in Sarla Verma,
Ji.
this schedule was modified.
Yes,
Schedule 2.
yes, my lord. Pranay Shetty simply वही तो हम बोला था खाली एक लाइन बोला
Schedule 2 is relatable to 163A or it is
That was-
relatable to
no.
166 also.
what happened my
So
lord
virtually through Sarla Birla, Schedule 2 has been brought in and is to be read with 166.
yes my lord.
Otherwise, as per the statute, it is not like that.
Earlier also my lord by way एक लाइन खाली सुन लीजिए in order to determine compensation which is just and reasonable that schedule was being adopted by everybody.
So that we are not concerned. When you are talking about strictly as per the statute, then under such circumstances, the schedule has been applied by the judgment of Sarla Birla,
Modified.
So-
Yes.
modified and applied.
Yes. Yes.
Modified and applied.
Yes, ma'am.
है ना मल्टीप्लायर तो उतना ही रखा होगा
मल्टीप्लायर को ही चेंज किया गया है एज के हिसाब
एज के हिसाब से जो
जो
मल्टीप्लायर
मल्टीप्लायर था उसी को केवल चेंज किया और कुछ नहीं किया गया
उसको 166 के कॉम्पनसेशन में अप्लाई कर दिया
तो
गया
पहले भी होता था सेम मेथड वाज देयर
पहले भी होता था एक्ट में है क्या
मेरा बात सुनो
therefore your argument that they are two distinct compartments
यस मैम
right
यस
they are distinct compartment because nobody can claim both
यस मैम
right that is to that extent it is okay but when it comes to calculation of income
No,
and
there are
taking care
two other things are there. 40,000 is the maximum income. Secondly, no need to establish negligence.
no that's okay
That is very relevant.
there is no
madam.
problem about it
Ah,
there is
yes,
no need
yes.
to establish
बस अब खाली मेरा बात सुन लिया एक बार तो schedule was held to be not correct. Therefore, in Sarla Verma, my lord, in order to standardize it, schedule was modified. It was made clear that it is only under section 166 future
आप मेरी
prospect
बात
will be
को
granted.
एक स्टेप पीछे ले as per the statute
My lord,
166 and 163 capital A
my lord.
are different and distinct.
Yes, my lord.
Schedule 2 is relatable to 163 capital A.
My lord.
Is there any schedule for 166?
No, my lord.
No. So therefore, so far as 166 is concerned, there were different parameters applied by various courts, and ultimately there was a requirement for standardization.
No, I will differ, my lord. Same schedule was being applied in 166 also for calculating the amount of compensation.
By virtue of which provision of law?
By virtue of, my lord, since it was a part of the schedule 2 is part of Motor Vehicles Act, this was how calculation was being
So
made.
therefore, so let us assume it this way. Schedule 2 was applied at par.
Multiplier.
Multiplier.
The table, the multiplier, age and multiplier, that was being applied at par in both 166 and 163A.
Under section 166, let us come back again. Under section 166, this particular table was being applied.
Yes,
Multiplier was applied.
Yes.
And apart from this, what other compensation was being paid?
Nothing was being paid. That was the only thing was being paid. And what happened was in some cases, the Honorable Supreme Court granted future prospect, and there was no basis for that. In some cases, it was 40%, in some cases, 100%. Therefore, need was felt that there should be standardization.
So, give me one reason as to why the schedule, which is initially relatable to 163 capital A and was subsequently adopted and was applied uniformly with respect to 166 also. Therefore, why this particular schedule as modified and as made applicable to 166 be not made applicable for
That
an
is
accident?
applicable.
No.
That is applicable.
With future
Multiplier
prospects. With
modif-
future prospects was being made.
No, that is not there. This is what I am trying to say. Multiplier which has been modified. For example, let me place it, my lord. For example, if a multiplier of 13 is there in schedule and it has been modified by Sarla Verma to be 15, that 15 has been applied in each case. 13 has not been applied, and I have not done that. So far as future prospect, even the Honorable Supreme Court is saying in Sarla Verma also, it is not a case under 163A, it is a case under section 166. And the difference between Sarla Verma and Procedural is very simple, my lord. Sarla Verma only said that future prospect will be payable to those who are in permanent employment. Therefore, the Procedural said that no.
For self-employed also it means.
Yes, that is the only difference.
That's right.
And the same multiplier mentioned in Sarla Verma has been adopted in Procedural also. No change was done in
So
that.
far as the calculation of income is concerned,
My lord.
right? So under the schedule, that has not been tinkered?
No.
Not tinkered. Okay. So under the schedule, there is no such income beyond 40,000.
Yes, my lord.
There is no such income.
No such.
So maximum income which one can think of is 40,000.
My lord.
Right. So if a person is having 1 crore rupees income,
He will apply 166.
he will he may apply under one. Suppose he applies under 163A, then he will be given compensation to the maximum of 40,000.
Here, my lord, that is for academic discussion. That is a very good thing, my lord. But here the inquiry is less than 40,000. 3,300 they have claimed, and they have got. They have themselves claimed 3,300, and that is less than 40,000. Secondly, my lord, in one case.
Do you think that the compensation would be just, irrespective of the fact whether it is relatable to income or not?
My lord, that what I think is not relevant here, my lord. But I am placing
We will
law.
think accordingly.
Yes, my lord may think. I am not disputing. My lord may think. My lord should think. I will say. But I am submitting on law only, my lord. One case went on to Supreme Court 163A. What happened, my lord, in that case? The deceased himself was negligent. Tribunal awarded in his favor. Insurance company went in appeal. High Court said no, he was negligent, he will not get anything. The claimant went to Honorable Supreme Court. 3 judges decided this issue and said that negligence is not required to be proved, which is already evident. But nothing was interfered with, only the multiplier, which was taken by the tribunal on the basis of age of parents of the deceased, that was modified to the age of deceased, and no change was made in the award. Can you see this? In this case, एक बार देख लिया इसको 2005
के जजमेंट को ऐसे नहीं पढ़ते हैं. सुप्रीम कोर्ट के जजमेंट को जो रेशियो डिसाइड होता है उसी अनुसार.
रेशियो यही माइलस खाली एक बार देख लिया जाए. अगर माइलस सुप्रीम कोर्ट का रहता कि फ्यूचर प्रोस्पेक्ट इसको जो मॉडिफाई किया गया है, इट इज नॉट दैट नथिंग हैज बीन इंटरफेयर्ड विद. एक खाली मेरे फॉर माय सेटिस्फैक्शन देखा जाए, माइलस विल काइंडली कम टू पैरा 8 जो ट्राइब्यूनल का क्या अवार्ड है, खाली हम दिखा देते एक बार. पैरा 8
whether this was the issue or not.
अरे भाई तो बात है, आप बहस किया ना, मैंने दीजिए. पैरा 8 देखा है. फाइनली गिवन दैट deceased was 28 years, that income was not proved, income was taken to be 36,000 per annum minus 1/3, which made 24,000 per annum. The multiplier was taken to be 8, keeping in view old age of the claimant, and accordingly a sum of 192,000 was arrived at. In addition, thereto 2,000 was given as funeral expenses, 5,000 as loss of consortium, making it a total of 1,99,000. This is the award of the tribunal, my lords. This was set aside by the Honorable High Court. Then, my lords, will come to last page.
ओल्ड एज का क्या फ्यूचर प्रोस्पेक्ट्स?
नहीं, ओल्ड एज फादर का था, my lords. He was only 28 years old. वही तो बोलना हम चाह रहे हैं ना कि ट्राइब्यूनल ने कहा कि मल्टीप्लायर विल बी एज पर एज ऑफ फादर. The Honorable Supreme Court says, my lords, can you see for a moment? पैरा 15
Old age of the claimant.
एक बार ओल्ड एज ऑफ द क्लेमेंट है पैरा 15 there we would have restored the MSCT judgment as it stands out but for the fact that there is glaring mistake in the multiplier as has been pointed out by Sri Sahu. Amount that will be paid will now be amount mentioned in MSCT judgment with the correction that multiplier instead of 8 is now 17. So the Supreme Court has modified with that also that future prospect has not been granted, 70,000 has not been granted. That was not done.
Future prospect 70,000 का क्या मतलब?
Future prospect has 70,000 under conventional heads.
Yes.
केवल 4,500 रुपया दिया गया है. That has not also been interfered with because my lord the law.
Claim ही नहीं किया ना?
My lord.
Claim ही नहीं किया.
नहीं नहीं तो
Argument ही नहीं किया.
ये भी तो क्लेम नहीं है my lords. पैरा 15 में जो मॉडिफाई किया गया है 8 को 17 से जो रिप्लेस कर दिया गया है that has been done suo motu by the honorable Supreme Court. Because law is well settled in by humble submission. So far as grant of just compensation is concerned, my lords, I will be the last person to say. लेकिन जो हम खाली लॉ पर बात कर रहे हैं बस.
So you want to say that whatever was his income on that particular day, on the particular date of death, it has to be calculated in that manner.
Yes,
And
future.
the schedule does not provide for any further income beyond 40,000. So therefore,
वो हम नहीं बोल रहे, वो हम अभी
वो
नहीं
है
बोलेंगे.
ना भाई, हम लोग जब कोई भी चीज को इंटरप्रेट करेंगे तो उसको कैसे आंख बंद कर लेंगे?
वो भी है.
The schedule is not providing any income beyond 40,000,
My lord.
right? So as per the schedule, the maximum highest compensation can be given only
My lord,
by treating the income as
I
40.
will again say, my lords, here their claim is only below 40,000.
Yes, their claim is below
Here in
40,000.
this case on facts I am saying, my lords, another case जिसमें होगा उसमें दिखाएगा अभी हम नहीं बोलेंगे.
ऐसा है कि जब किसी प्रोविजन ऑफ लॉ को इंटरप्रेट करते हैं ना,
इसमें
सारे
है।
एक्सट्रीम्स को देखकर इंटरप्रेट.
Yes, ये जो जजमेंट हमने दिया है उसमें यही बात लिखा हुआ है कि लॉर्ड 40,000 ही
प्रणय
consider
शेट्टी में जो बोल रहे हैं कि 163 capital A was not involved, he has
Yes.
shown it from this
सरला
that,
वर्मा-
that the very reference was because of this difference of opinion.
163A का जो रेफरेंस था सिक्किम वाला जो बोल रहा है ना.
नहीं नहीं ये the reference judgment noted divergence of opinion with regard to computation under section 163A and 166 of Motor Vehicle Act. So divergence of opinion under section 166 and 163 capital A was the main issue before the court. So therefore the court, while determining as to what would be the income, took into consideration that future prospects has
वो
to be
लास्ट में नहीं
considered.
लिखा हुआ है कि 163A में भी करना है. केवल इतना कहना मतलब मेरा बात सुन लिया जाए. सरला वर्मा
अच्छा
में
एक
जो
बात बताइए, in determination of income
my lord.
under section 166 and determination of income under section 163A would be different according to you. Future prospects नहीं लेंगे तो different हो जाएगा.
ओरिजिनल जो इनकम है वो तो ओरिजिनल ही रहेगा मतलब उसके बाद फ्यूचर प्रोस्पेक्ट ऐड होता है.
हाँ, उसी इनकम में ऐड होता है.
हाँ.
इनकम में ऐड होता है and that is treated as income and then the calculation is made,
My lord.
isn't it?
तो जो पार्लियामेंट का इंटेंशन था कि एक शॉर्टकट स्कीम है इसमें जो लोग इन्वॉल्व करें उनको तुरंत पैसा मिल जाएगा वो स्कीम और फिर इसका कोई रिडंडेंट वर्ड्स एवरीथिंग सेम देन देयर विल नो नीड. और आज के दिन में मान लो काइंडली अप्रिशिएट वन थिंग, आज जो अमेंडमेंट हुआ है उसमें फाइनल फिक्स कर दिया गया है 5 लाख रुपया 163A वाला जो उसका रिलेवेंट जो सेक्शन है उसमें आ गया टोटल 5 लाख. किसी का कितना भी तनख्वाह हो, इफ ए पर्सन फाइल्स अ केस अंडर दैट सेक्शन दे विल गेट 5 लाख ओनली. ये लेटेस्ट जो अमेंडमेंट है पार्लियामेंट का.
बट अगेन इन दैट वो अगर 100 रुपया भी इनकम है तब भी 5 लाख ही मिलेगा.
हाँ मिलेगा
दोनों चीज है.
जो भी
यहाँ
है.
पर-
तो कहने का मतलब भाई हम दूसरा बात बोल रहे हैं, आप हमको बोलने ही नहीं देते हैं. मेरा कहना ये है माय लॉर्ड्स कि एक स्कीम है गवर्नमेंट पार्लियामेंट का, अदरवाइज दैट विल बी नो नीड ऑफ 163A. स्कीम उसकी बनाने की जरूरत ही नहीं था, खाली इतना कह देना था 166A में एक कॉलम जोड़ के प्रोवाइडेड दैट इवन इफ देयर इज नो नेग्लिजेंस इज प्रूव्ड इट विल बी एंटाइटल्ड. वैसा नहीं किया गया. तो कुछ यही डिस्कस किया गया उस जजमेंट में और देख लिया जाए माय लॉर्ड्स. हमको इसमें हम एज आई एम असिस्टिंग योर लॉर्ड्स.
और झारखंड में फॉलो क्या होता है?
झारखंड में तो अभी तक ये हमेशा अभी तक यही हुआ है. अब ऐसा कोई जजमेंट रिपोर्टेड नहीं हुआ. हम लोग आज तक फ्यूचर प्रोस्पेक्ट 163A में नहीं दिए, मतलब ऑर्डर नहीं हुआ है मेरे नॉलेज में.
लेकिन जो फ्यूनरल वगैरह होता है वो सब
वो हम
सल्ला पिल्ला के हिसाब
आजकल
से,
स्टैंडर्डाइज्ड है माय लॉर्ड्स. वो दिया क्योंकि
मतलब स्टैंडर्डाइज्ड फ्यूनरल वगैरह है लेकिन इनकम कैसे डिटरमाइन होगा वो स्टैंडर्डाइज्ड नहीं.
दैट इज डिफरेंट थिंग. जो रेट आज के दिन में जब फिक्स हुआ था 2,500 रुपया, माय लॉर्ड्स विल काइंडली अप्रिशिएट वन थिंग. 2500 को आज 25,000 कर दिया गया।
अब
क्यों?
इसको दूसरे तरह से सोचिए, अगर मान लीजिए हम लोग इनकी बात को मान लेते हैं, सो व्हाट विल बी द डिस्टिंक्शन इन द क्वांटम ऑफ कॉम्पनसेशन अंडर सेक्शन 166 एंड 163 कैपिटल? क्वांटम तो सेम रह जाएगा। अगर मान लीजिए नेग्लिजेंस प्रूव हो जाता है, ठीक है, तो 163 कैपिटल ए में एंड 166 में क्वांटम ऑफ कॉम्पनसेशन में क्या अंतर?
2 लाख बढ़ जाएगा, फ्यूचर प्रोस्पेक्ट मिलेगा।
फ्यूचर प्रोस्पेक्ट क्या फिक्स्ड है?
40 यस फिक्स है, जो सेल्फ एम्प्लॉयड है एज के हिसाब से फिक्स है।
अच्छा,
बिलो 40 इयर्स है, अगर मान लीजिए सेल्फ एम्प्लॉयड है 40%, कोई परमानेंट जॉब
40% ऑफ द इनकम।
इनकम, कोई गवर्नमेंट एम्प्लॉय है या परमानेंट जॉब में है, 40 से कम है तो
नहीं, आप मेरी
50%।
बात नहीं समझ रहे। अगर मान लीजिए 166 में किसी का डिटरमिन, अगर इनकी बात मान लेते हैं, ठीक है, तो द क्वांटम ऑफ compensation arising out of loss of income,
My lord,
which will include future prospects,
My
right?
lord.
For quantification under section 166 and for quantification under section 163 capital A would become the same
yes, same
हो जाएगा।
जी।
तो फिर लोग क्यों जाएगा 166 में? वो बोलेगा 166 163 ए में ही जाना ठीक है।
वही तो हम बोल रहे हैं, इसी माय आर्गुमेंट में।
सुनिए एक सेकंड, कौन सा जजमेंट रिलाई कर लिखे तो हर्ट द लर्नर काउंसिल फॉर द पार्टीज। The sole issue involved in the present case is as to whether the learned court has erred in adding future prospects to the income of the deceased,
Not adding income.
but
Not
in not adding future prospects to the income of the deceased while granting compensation under section 163 capital A of Motor Vehicles Act. The learned counsel appearing on behalf of the appellant has relied upon the judgment passed by Honorable Supreme Court reported in bracket 2009 bracket close 14 SCC 1 R.K. Malik and another versus Kiran Pal and others, and has referred to paragraph
36.
36,
I have written.
paragraph 36 of the said judgment to submit that in the said case the matter was arising out of quantification of compensation under section 163 capital A of Motor Vehicles Act, and future prospects was taken into consideration while granting compensation. He has further referred to the judgment passed by Honorable Supreme Court in the case of in the case reported in bracket 2017 bracket close 16 SCC 680 within bracket National Insurance Company Limited versus Pranay Shetty to, and has in particular referred to the reference before the Honorable Supreme Court as mentioned in paragraph 3, and has submitted that the reference judgment noted divergence of opinion with regard to computation under section 163 capital A and 166 of the Motor Vehicles Act 1988 and the methodology for computation of future prospects. The learned counsel submits that the said judgment dealt with computation of income under section 163 capital A as well as section 166, and therefore in order to arrive at just compensation the future prospects is to be taken into consideration as is admittedly applicable while computing compensation under section 166 of Motor Vehicles Act.
Para 57.
He has in particular referred to para
5 and 7.
55 to 57 of the said judgment.
That's
The learned counsel further submits that the judgment passed, the aforesaid two judgments have been followed by different high courts to grant compensation by taking into consideration future prospects. Those are the judgment passed by
Guwahati.
Guwahati High Court, Bombay High Court पहले आप refer कीजिए.
Yes.
Judgment passed by Honorable Bombay High Court in first appeal number 250 of 2019 within bracket Tata AIG General Insurance Company Limited versus Srimati Mauri, Mahesh Rane and others, dated 23rd of December 2022, and he submits that the future prospects was taken into consideration by the court concerned and the Honorable High Court refused to interfere with the same.
Madam, that's it.
He has thereafter interfered with that same by referring to the judgment passed in the case of Pranay Shetty, Supra. He further relies upon the judgment passed in इतना सा नहीं होगा judgment passed by Honorable Guwahati High Court in the case of New India Assurance Company Limited versus S. Munna and others in MSC number 17 of 2017, decided on 17/11/2017, and has referred to paragraph 16 thereof.
9 and 17.
Paragraph
9 is the issue where the court, and 17 is the finding.
paragraph 9
9 is
9 नहीं 10 है ना
10.
दो judgment
9 10 9 10.
9 तो खाली
Why
I heard
I heard 10 10 10.
para 10
And 17
and
is the finding.
17 of the said judgment. 10, 16 and 17 of the said judgment. He has also relied upon the judgment passed by the High Court of Guwahati High Court in the case of New India Assurance Company versus Srimati Lancy in MS reported in 2022 Supreme within bracket DAU bracket close 365
Para 12.
paragraph 12 within bracket Roman 3 was the issue framed.
19 is the answer.
And he submits that the same has been answered in paragraph number 19 of the said judgment by following the case of R.K. Malik, Supra. ये हो गया आपका.
And one Delhi High Court judgment.
He has also relied upon the judgment passed by Honorable Delhi High Court in
2017 SCC online
2017 SCC Online
11706.
11706.
3 and 5.
Within bracket Oriental Insurance Company Limited versus Mamta Singh, and has referred to paragraph 3 and 5 of the said judgment to submit that the Honorable Delhi High Court has also recorded that the decision in Pranay Shetty's case makes no distinction between a claim under section 166 and a claim under section 163 of Motor Vehicle Act for assessing income. The learned counsel submits that different yardstick cannot be taken for the purposes of assessing income while granting compensation under section 163 capital A of Motor Vehicles Act on the one hand, and while granting compensation under section 166 of the Motor Vehicles Act. The learned counsel appearing on behalf of the respondents on the other hand while opposing the prayer has submitted that it has been held by the Honorable Supreme Court in numerous judgments that the provision of section 163 capital A is a self-contained code and it arises out of payment of compensation even in cases where there is no negligence. The learned counsel submits that it is certainly open to the claimant to invoke section 166 or 163 capital A, whatever he deems proper, and there is no overlap between the two. He submits that the principle of computation under section 163 capital A is different from that of 166 of Motor Vehicles Act, and therefore the question of adding future prospects to the income while calculating the income of the deceased under section 163 capital A cannot be applied. The learned counsel has also submitted that another bench of Honorable Bombay High Court
Aurangabad
at Auranga bench in first appeal number 1403 of 2017 has taken a different view, and the entire provision has been taken into consideration while holding that the judgment passed in the case of Pranay Shetty is not applicable in claims filed under section 163 capital A of Motor Vehicles Act. The learned counsel submits that not only the aforesaid judgment but other judgments have been also referred to in paragraph 10 of the said judgment. The learned counsel has further referred to the judgment passed by Honorable Sikkim High Court, reported in 2022 SCC online SIAA 26 within bracket branch manager Shriram General Insurance Company Limited versus Dilu Rai and others, to submit that the entire history of insertion, history of amendments made from time to time and insertion of section 163 capital A has been considered by the Honorable Division Bench, and ultimately it has been held that once a person invokes the provision of section 163 capital A, the question of inclusion of pecuniary compensation for non-tangible and future prospects does not arise. And the learned counsel has also submitted that the ratio of the judgment, it has been held that the judgment passed in the case of R.K. Malik, Supra, which in turn referred to the decision in the case of Lata Vadva versus State of Bihar, was held to be of no relevance, as those were the matters concerned with death of minors who were non-earning members. The Honorable Court has held that under section 163 capital A, future prospects or any other additional non-pecuniary heads finds no place, and compensation in a claim petition under section 163 capital A of the Motor Vehicles Act is to be strictly computed on the structured formula provided in the second schedule to the Act. The learned counsel submits that those heads which are mentioned in the schedule and pronouncement has been made by the Honorable Supreme Court in the case of Pranay Shetty stand modified to that extent, but there is no reference of any future prospect in the second schedule, and therefore future prospect cannot be included while computing income under section 163 capital A of Motor Vehicles Act. The Learned Counsel has further submitted that if the future prospects is added to the income while computing income under section 163 capital A, then there would be no difference in the quantification of final compensation under section 166 capital A, 163 capital A and 166 of Motor Vehicles Act. He submits that the other heads which are mentioned in the schedule are absolutely common, under which compensation is payable under section 166 of Motor Vehicles Act. यही है आपका टोटल?
ये पैरा 13
ये
है।
बात आपका लिखाए हैं, ये बात सच है ना?
यस मैम, हम कभी
इसमें कोई
गलत नहीं
कंफ्यूजन
बोले।
नहीं है?
नहीं।
Arguments concluded.
ये वाला जस्ट रेफरेंस के लिए दे दिए थे, पैरा 13 है, खाली उसको याद रखने के लिए है, दे दिए हैं ऑलरेडी।
कौन सा?
जो ऑब्जर्व किया ऑनरेबल सुप्रीम कोर्ट ने कि इट इज नॉट अ केस अंडर सेक्शन 163A, जो
हाँ।
इमीडिएट जो 25,000 दिया गया था,
हाँ,
जो मे बी करेक्ट वाला
मे भी करेक्ट नहीं है। वो लिख रहा है कि द कंटेंशन,
ये कौन सा वाला? एक सेकंड रुक
जो ऑनरेबल सुप्रीम कोर्ट का जो माइनर्स बोल रही थी
Para
2009
13.
वाला, उसका पैरा
Correct.
13।
The Learned Counsel has also relied upon the judgment passed by Honorable Supreme Court, Respondent Kalkira, reported in bracket 2009, bracket close 13, SCC 654, para number 13, to submit that the Honorable Supreme Court has considered the arguments advanced on behalf of the insurance company and has observed that it may be correct to some extent that for the purpose of computation of total income of compensation under section 163 capital A of Motor Vehicles Act, the future prospects may not be of much relevance. But in a case where claim petition has been filed in terms of section 166 of the Act, the same would be a relevant. He has also submitted that the judgment passed in the case of bracket 2009 bracket 13 SCC 654 has been passed by the same bench of the Honorable Supreme Court, which is reported in bracket 2009 bracket close 14 SCC 1, which has been heavily relied upon by the Learned Counsel for the Act. The date of judgments are 6th May 2009 and 15th of May 2009. इसमें जजमेंट का डेट दीजिए, बिना डेट के हमको दिक्कत लगता है।
नॉर्मली सब केस ऐसा नहीं होता, कोई केस में ऐसा होता है, अदरवाइज सिंपल केस कैलकुलेशन देने से ही हो जाएगा।
डेट केस में कोई डिस्प्यूट रहा नहीं है। 163A किस
हम लोग कैलकुलेट
भले है चाहे नहीं है, लेकिन ये पूरे स्टेट के लिए तो बहुत इम्पोर्टेंट है ना। 163A का कैलकुलेशन हो
ये
रहा
बहुत
है,
इम्पोर्टेंट है।
सब लोग अपने हिसाब से कर रहे हैं। हाई कोर्ट में बैठ के हम लोग का क्या काम है? खाली कंप्यूटेशन करना इज नॉट आवर वर्क। आवर वर्क इज टू सेटल।
इसमें यहाँ पर ये केस में है, अदरवाइज हम जनरल केस की बात कर रहे हैं कि इसमें ज्यादा कुछ नहीं है, हम लोग
नहीं,
कैलकुलेशन
163A में कैसे कैलकुलेशन? अभी छोड़ दीजिए, अभी नहीं उठेंगे। 163A में जनरल जगह पे कैसे कैलकुलेशन हो रहा है?
यही मल्टीप्लायर लगता है, सेम मल्टीप्लायर लगता है, खाली फ्यूचर प्रोस्पेक्ट नहीं दिया जाता बस, क्योंकि मल्टीप्लायर हैज बीन हेल्ड टू बी रिमाइंडर्स रॉन्गली फ्रेम्ड।
जनरली ऐसा शायद ना हो, क्योंकि इस जजमेंट में व्हिच इज अंडर चैलेंज बिफोर यू लॉर्ड दैट इसमें 1/4 डिडक्शन हुआ है। अंडर 163A 1/3 होना चाहिए। फ्यूचर प्रोस्पेक्ट्स और बाकी कन्वेंशनल हेड में टोटल 70,000 मिला है। अगर शेड्यूल से जाते हैं तो मात्र और मात्र मुझे 9,500 मिलना चाहिए। एंड व्हाई दीज थिंग्स हैव हैपेंड only because of prenacity by that judgment, and that judgment has been taken into consideration. But future prospects को discuss ही नहीं किया गया.
The entire impugned judgment is based on prenacity.
Prenacity, because 1/4 is also
The learned counsel appearing on behalf of the appellant in response has submitted that the entire calculation in the impugned judgment is based on the judgment passed by the Honorable Supreme Court in the case of Pranay Shetty, except that the impugned judgment is absolutely silent with respect to future prospects, which was also a part of pronouncement by the Honorable Supreme Court in case of Pranay Shetty.
Yes.
Okay? September 30th.
Okay.
Appearance with
Open-ended judgment हम नहीं छोड़ेंगे, इतना बोल सकते हैं. Somebody will have to go and appeal to set it aside. बस. हाँ, आपका कहाँ है आपका? What is it?
item 41.
कल ही एक इलेक्ट्रिसिटी बोर्ड का नया जजमेंट आया है सुप्रीम कोर्ट का, बिहार से गया था, ऑन रेट्रोस्पेक्टिव प्रमोशन पर आया. देखें
आज आएगा लाइट लॉन्ग.
आज आया कि कल आया, आई डोंट नो, इसको देख लेते हैं. उसमें लेकिन शायद वो नहीं डिस्कस किया, अगर किसी जूनियर को दे दिए हैं तो क्या होगा.
नहीं वो नहीं. From the date of vacancy नहीं होगा,
हाँ.
from the date of grant होगा. That is the.
Yes, anyway, this was off the field.
Yes. Page 35. Let's straight away we can come. Page 35 calculation.
Yes, page 35.
Yes.
Yes.
Annual income is 651,286 minus 29880. That amount comes to 621,406. Thereafter, we have 621,406 minus for personal expenses, that is 414,2731. So 538 is the amount on which 30% future prospects should have been added. Next page, Manoj.
Yes.
What the traveler has done is he has subtracted from that and he has added 414,271 minus of 30% कर दिए. जबकि होना था 538 5523 का 30% add होना चाहिए. That calculation is
वो पर मंथ कर दिए हैं.
yes.
हाँ.
पर मंथ नहीं किया, वो एक्चुअल सैलरी जो है वो 414,271
होता क्या
है.
लॉर्डशिप, इनकम के बाद फ्यूचर प्रॉस्पेक्ट ऐड करके सब कैलकुलेशन
ठीक
किया
है,
जाता
तो इनकम तो इनका 414 डिटरमाइन हुआ ना.
हाँ 414 डिटरमाइन हुआ, मल्टीप्लाई ऐड करके 538 हो गया.
538 हो
उसके
गया.
बाद 30% जो ऐड किया गया 414 पे ऐड किया गया.
538 पे नहीं किया.
अच्छा अच्छा, ये गलती है. This is a calculation है ना.
And one more thing is the percent
खाली में कंसेशन नहीं लिखा जाए
नहीं
बस.
नहीं, कंसेशन क्या है इसमें, क्या है? हाँ बोलिए.
interest part page 37 minutes.
कायदे से इसमें 414,271 में इनको 124,281 ऐड करना था एंड देन मल्टीप्लाइड बाय 13 करना था.
इधर वेज
इधर वेज
हाँ.
Either ways.
नॉर्मली
वो इनकम लेते,
हाँ,
इनकम में 30% ऐड
ऐड
करते,
करते और उसके बाद पूरा कैलकुलेशन.
उसके बाद पूरा कैलकुलेशन वो इनकम को पकड़ के
जी
करते.
जी जी यही
Right?
होता है, यही होता है.
ओके, व्हाट एल्स?
And one is page 37 is the interest part. Is
सिर्फ penal interest दिया है.
6% per annum from the passing of this order कर दिए हैं. I was praying for 9%, but my learned friend says that after Dharampal's judgment, generally our honorable high courts have 7.5% the bank interest.
धर्मपाल कौन सा चाहते हैं?
इनका
नहीं
ये
लिखा
क्या
दिए
है?
हैं 2008 का. बेसिकली व्हाट ट्रांसपायर्ड इज धर्मपाल जजमेंट में बोला गया कि प्रिवेलेंट बैंक रेट ऑफ इंटरेस्ट, प्रिवेलेंट बैंक रेट ऑफ इंटरेस्ट इज द टचस्टोन. तो उसी में धर्मपाल जजमेंट में बोला गया 7.5% और आज तक अभी जो है हम लोग
कंसिस्टेंटली 7.5% फॉलो कर रहे हैं.
जी मैम 2008 वॉल्यूम 12 SCC
208.
2008
Volume 12 SCC
208 para number
14.
para 14. These are the two
Calculation my learned friend.
ये from the date of
फाइलिंग हो
filing
जाएगा
हो
फ्रॉम द
जाएगा।
डेट ऑफ फाइलिंग
फाइलिंग और एक्सीडेंट और फाइलिंग में कितना फर्क है?
एक्सीडेंट WC में चला जाता है, स्टैट्यूटरी हो जाता है, और यहाँ पे फ्रॉम द डेट ऑफ फाइलिंग होता है।
नहीं हम जानना चाहते हैं
मतलब
फाइलिंग कब हुआ है इसमें?
2018 का।
फ्रॉम द डेट ऑफ फाइलिंग होना चाहिए।
हाँ। 20 से 18 को फाइल हुआ था, एक्सीडेंट है जनवरी का, 5 महीना का।
20/6/18 को फाइल हुआ था, तो इस डेट से आपका
जी।
होना चाहिए। ओके। Heard the learned counsel for the parties. This appeal has been filed against award dated 18/3/2020, passed by learned district judge Roman 4, cum presiding officer MACT Bokaro in compensation case bearing motor accident claim case number 66 of 2018, whereby the claim has been partly allowed, and he has been pleased to direct respondent number 3 to pay an amount of rupees 55,79,804 within 1 month from the date of the award, failing which the respondent number 3 insurance company shall be liable to pay penal interest at the rate of 6% per annum from the passing of the order till realization. ये डिफॉल्ट क्लॉज की तरह है इसमें।
हाँ, वही पिनल इंटरेस्ट दिया है।
और वैसे कोई इंटरेस्ट नहीं दिया, देते भी नहीं है।
देते
देते हैं।
वही तो, this is too much. The learned counsel appearing on behalf of the appellant while assailing the impugned award has submitted that the learned court has made calculation error while computing the future prospect. She submits that the 30% of future prospect was to be added to the salary determined, and then it was to be multiplied by the multiplier applied in the present case, that is 13. She submits that future prospect has only been computed for 1 month's salary, which is 1 month's salary.
1 month 441 entire annual salary है।
Okay. For only 1 year's salary, and there is a computation error. She has further submitted that the rate of interest which has been awarded by the learned court is to the extent of 6% per annum from the date of passing of the order till realization. She submits that the rate of that the interest ought to be awarded from the date of, ये तो penal interest है ना, इसमें तो दिया ही नहीं है वो।
वही हम बोले पिनल इंटरेस्ट है।
फाइलिंग से होना चाहिए था इंटरेस्ट।
इसमें फाइलिंग सही है, इंटरेस्ट 7.5%
हाँ।
rate.
But my prayer may be written as 9% or after his objection it may be 7.1 because
हाँ,
we
तो
have
हमको
prayed
भी
for
बोलने के लिए अच्छा
9%.
रहेगा।
The learned counsel has submitted that the rate of interest has been wrongly mentioned, the learned counsel submits that the interest ought to have been awarded at least from the date of filing at the rate of 9%, but the learned court has awarded interest only upon default in making payment within a period of 1 month from the date of award, that too at the rate of 6%. The learned counsel appearing on behalf of the respondents has opposed the prayer.
Respondent number 3।
Respondent number 3. बाकी कौन?
बाकी
आपको
owner
राइट ऑफ
actually-
रिकवरी भी
नहीं,
है, बाकी कोई मतलब नहीं है. The council appearing on behalf of the respondent number 3, though has opposed the prayer, but to the extent it relates to computation error as is apparent from the impugned award, he has no answer. So far as the rate of interest is concerned, he has submitted that at best 7.5% can be awarded in terms of the judgment passed by the Honorable Supreme Court, quoted in bracket 2008, bracket close 12 SCC 208, para 14. ये judgment लाए हैं? नहीं मिलेगा ना तो
नहीं,
हम delete
हम अभी
कर
दे
देंगे.
देते हैं, हम अभी दे देते हैं।
अगर हमको ये इस para 14 में नहीं मिलेगा तो इस पोर्शन को हम डिलीट कर देंगे.
पढ़ के सुना.
ओके.
है, हम दे देते हैं,
एक महीना में तो पेमेंट आप नहीं किए होंगे, तो इसीलिए डिफॉल्ट क्लॉज का तो अब कहानी खत्म हो गया.
ऐसे भी फ्रॉम द डेट ऑफ फाइलिंग हो जाएगा.
After hearing the learned counsel for the parties and considering no other point has been argued by the learned counsel for the parties. After hearing the counsel for the parties, this court finds that the annual income of the deceased was calculated at rupees 6,21,406, and upon deduction of 1/3 of his personal expenses, it came to rupees 4,14,271. The multiplier to be applied was 13, and therefore further this court finds that the future prospects to the extent of 30% of the salary was to be added. Consequently, 30% of the salary was to be added to rupees 4,271, which would have been the annual income of the deceased, and the same ought to have been multiplied by 13 to come to the quantum of
ये
compensation.
जो 30% ऐड होता है वो एनुअल इनकम 621 में ऐड होता है.
621.
एनुअल इनकम में 30% ऐड होता और उसके बाद बाकी कैलकुलेट होता. 421 जो है 414 जो है इट इज 1/3 माइनस करने के बाद आया.
माइनस
कैसे उसमें 30% ऐड होता है उसमें?
एनुअल इनकम पे डिडक्शन के बाद में होता है.
सिक्स 21 तो फिर तो डिडक्शन 1/3 भी गलत हो गया.
नहीं 1/3 तो नहीं.
नहीं अगर मान लीजिए 621,406 में
उसमें 30% ऐड हो जाएगा
उसके बाद रिडक्शन.
और
उसके बाद 1/3 डिडक्शन
उसके
होगा.
बाद 1/3 और ये फिर क्या बोलते हैं मल्टीप्लाई 13. उसमें हम जजमेंट दिखा देते हैं. प्रणय शेट्टी का ये
दिखाइए प्रणय शेट्टी. While determining the income, an addition of 50% of actual salary to the income of the deceased should be added as future prospects.
माइनस एनुअल इनकम से. सॉरी लॉर्डशिप वो
आप
जजमेंट
लोग सबमिशन में तो ऐसा नहीं ना बहस किए, जब डिक्टेशन दे रहे तब आप ऐसा बात.
नहीं तो बोले एनुअल इनकम ऐड होना चाहिए. आंसर ये
आप
तो
कैलकुलेशन दे देंगे?
हम दे देंगे अभी. बना देते
ठीक है, बना
हैं. ये
दें.
पैरा 14 वही है डार्क लिखाएंगे.
दो though there are judgments of this honorable court for 9%, but my learned friend has literally threatened me that if you say 9%, I will object till Supreme Court. So I thought better she gets 7.5%, she'll get the interest.
आपको डरा के कौन जी सकता है झारखंड
वही
हाईकोर्ट
बोल-
में? जिंदा रहना है कि नहीं उनको?
डरा दिए बात.
Yeah, but on a serious note, 7.5% we are consistent all together also.
An amount of rupees 30% was to be added. An amount to the extent of 30% was to be added to rupees 6,21,406
जी.
to determine to include the future prospects, and the same was to be, and thereafter 1/3 was to be deducted,
Yes. And then multiply.
and then the multiplier of 30 was to be applied. The calculation on this principle, as furnished by the learned counsel appearing on behalf of the insurance company, is as follows. Correct calculation
नहीं
on
हम
this.
हम कर देते हैं बट इनके तरफ से कर लिया
नहीं calculation ही sir.
बट फिर मेरी तरफ से इनके तरफ से कर दिया जाएगा.
इसके बाद
हम कर देते हैं बट
ठीक है, आप कर दीजिए. The calculation on the basis of this aspect of the matter is as follows. पूरा ही करना पड़ेगा ना,
जी
पूरा amount.
पूरा A to Z पूरा कर देते हैं.
Considering the aforesaid findings, the appellant would be entitled for compensation to the extent of rupees जो भी एक dash है ना, subject to deduction of rupees 50,000 if already paid under section 140.
प्लस बाकी अमाउंट इफ पेड.
हाँ, यहाँ जमा तो नहीं किया होगा,
नहीं वो कर दिया.
कर दिया. ठीक है. So far as the interest is concerned, in view of the judgment passed by the Honorable Supreme Court in the case of Dharampal and others reported in bracket 2008 bracket close 12 SCC 208, the appellants would be entitled for interest at the rate of 7.5% from the date of application till the date of payment. The impugned award is accordingly modified. Appeal party allowed. अब तो हम सारे जजमेंट्स इकट्ठा कर रहे हैं मोटर व्हीकल्स वाले.
From daily list, orders with effect item 1, MA 141 of 2023.
Yes. कोई डिफेक्टिव पिटिशन है, आज तो डिफेक्टिव टेकअप ही नहीं है. 2 weeks टाइम. आज तारीख हो गई 24. Time till 14th August is granted to the appellant to remove the surviving defects preemptory if the defects are removed within time. Pose this case on 20th August, 20 August. 14 August.
Item 2, MA 142 of 2023.
Same order. Same order.
Item 3, MA 14423 of 23.
Same order. कोई नहीं, same order. इसको जरा चेक करिएगा, कोई रिकॉर्ड भेजने वाला तो कोई डिफेक्ट नहीं.
Item 4, MA 148 of 2023.
सेम ऑर्डर. इससे ज़्यादा टाइम नहीं देंगे. सेम ऑर्डर 14 अगस्त.
Item 5, MA 253 of 2023.
सेम ऑर्डर. नेक्स्ट.
Item 6, MA 6 of 2024.
सेम ऑर्डर.
Item 7, MA 10 of 2024.
Same order.
Item 8, MA 11 of 2024.
Same order.
Item 9, MA 12 of 2024.
Same order.
Item 10, MA 20 of 24.
Same order. Orders में
Orders.
आइटम 10 में डिफेक्ट्स रिमूव कर दिए
कर दिए हैं.
एक आईए लिमिटेशन पर था वो उसके लिए आईए भी फाइल कर दिया गया और आईए का नंबर भी आ गया
Council. Serial number?
10.
Serial number 10. Council for the appellant submits that the defects in the case have already been removed. Office to check post day after tomorrow.
Orders item 11, MA 74 of 2020.
आज एक मैटर था वो. Yes.
Let's see, this is we referred by the insurance company. We have moved an application for stay. Leadership, if this matter can be disposed of, it would be better. I'm ready to argue next week.
No, you first deposit, then we will. Otherwise, you don't need a stay. You withdraw your IA, I will fix a date.
No, leadership, there is an execution.
Therefore, you deposit. It's a money decree. You deposit
money
entire
decree.
amount.
We will deposit, but the ground taken in the memo of appeal is such that
It's a money decree. You deposit. उनको थोड़ी पैसा दे रहे हैं आप जमा करिए.
yes,
कब जमा करेंगे?
it will take some time because the check has to be prepared from South India, so it will take some time.
एग्जीक्यूशन में आपको टाइम नहीं लग रहा है. हाँ, आप सभी रिस्पोंडेंट को रिप्रेजेंट कर रहे हैं.
Claimants,
claimants.
only claimants.
Only claimants. There is no other private respondent.
There is a owner also, but he has the copy has been received by himself, but he has not appeared. The appeal is confined to the quantum, so even if he doesn't appear, notice has been served upon him as per the process of
There is no direction to realize. No direction to realize.
There is interest also. If not paid.
No, we have raised a specific plea that as regards the claim of the claimants that the deceased was actually deriving the income, entire income from his this HUF, Hindu Undivided Family Business. So the loss of dependency would be only restricted to the level of the personal skill of that man involved. The entire amount could not have been taken for assessing the loss of dependency. This is a question which has not been determined by the Honorable Supreme Court. And Your Lordships, this question was once determined by the full bench of Karnataka High Court. So I have an arguable case. So I just want to, I pray before Lordship's discretion is there. If Lordship directs, we'll pay the entire amount. But Ladyship, the
अब बहस करिए. रिकॉर्ड आ गया.
LCR is
बस रिकॉर्ड आप किया. कब करेंगे? Next week.
yes, much obliged.
The records have already been received. Counsel for the parties jointly pray that the matter be placed for final disposal. Counsel for the appellant, by advancing his argument, has submitted that the core issue involved in the present case is that the income of the deceased was primarily from fixed deposits from
Hindu Undivided
HUF
business.
HUF business, and therefore the income from such business could not have been taken into consideration for calculating the compensation, as it did not relate to his personal skills. Okay? He has also submitted that the business through HUF would continue to give profits irrespective of death of the deceased. यही है?
स्किल वाला में जो लिखी है ना मैम, वो है एज पर द फुल बेंच
आप लेके
अप
फुल
टू
बेंच
द
का
लेवल ऑफ स्किल ये प्रूव करेंगे टू दैट इफेक्ट ओनली द लॉस ऑफ डिपेंडेंसी कैन एक्रू टू देयर बेनिफिट.
ठीक कहाँ है कर्नाटका हाईकोर्ट?
यस प्लीज.
He has relied upon a judgment passed by full bench of Honorable Karnataka High Court.
आई एम गिविंग हिम फर्स्ट.
ये सारे इश्यूज अपने हाई कोर्ट में नहीं डिसाइड हुए हैं.
अभी तक तो नहीं है.
अरे इतना साल से एमबी एक्ट चल रहा है, आप लोग डिसाइड नहीं कराते हैं.
मेरे पास तो आता जरूर कहते हैं, आलोक लाल के पास ज्यादा केसेस था तो
आपको देखिए अभी वो सुन लेंगे ना तो आपको बहुत ज्यादा डांटेंगे. Reported in ILR 2001 Karnataka 1443 within bracket P Parimala and others versus
It's a
Riaz
division.
Ahmad and
इट्स अ डिवीजन बेंच. सॉरी.
इसको टैग करिए. पैरा नंबर कुछ है इन पर्टिकुलर? अच्छा छोड़िए, हमको वैसे ही पूरा पढ़ना होगा. फाइनल डिस्पोजल ऑन नेक्स्ट थर्सडे.